And I apologize, the streaming is still not working. There's something wrong with my with the connection between my camera and YouTube. I don't know quite what the problem is, but I'll try and figure it out over the weekend. All right, I think we have just about everyone. Please sign to the attendance when you can. Okay. Questions before we get started? Anything on your minds? I still have not gotten your midterms. I'm starting to get annoyed. I've asked like 3 times and not gotten the files yet. I will be patient. People are very busy. The school is very... It's hard running a virtual school. I don't think you students are quite given all the details, but the amount of work that has to be done to make this function is ridiculous. I've had more faculty meetings in the last year, or the last 6 months. I think I had my first 8 years at this school. Just the amount of work it takes to make this function virtually is ridiculous. Do you know what the school's doing for graduation? Have they told you this? Because George R. Brown, the convention center, can't host us, the school's hosting small graduation ceremonies in the building. They're hosting 13 separate small graduation ceremonies. 13, with like 10 people at a time to have their families to come in. So the auditorium that's on the second floor, blanking the name. It's a huge auditorium on the second floor. They're having 13 separate graduation ceremonies. Basically, the dean will come in 13 times a weekend too. That's ridiculous. I don't think any other school in the country does that. The amount of attention and care that this administration is giving, I'm blown away. I'm happy to comply and go along and just be in awe. But it's just really impressive that these students who graduated this past May will get 13 graduation ceremonies. That way they can bring their friends and family. I think that George R. Brown said that people could bring 2 guests, and that was it, to do the distancing. And the school said, no way, not doing 2 guests. So it's just, but it's a lot of work. My point is, so when things don't happen right away, I just have to sort of just let them slide and say, okay, we'll get to it when you get to it, because they're doing more important things, I think. But we'll get there. And I think with the midterms, what I'll try is maybe one weekend, not this weekend because I haven't even seen the papers yet, but maybe the following weekend. I guess that'll be the weekend of the maybe the 23rd. That's right, the 24th. I got to figure out the details. Maybe the weekend of the 24th, I'll just set a block of hours and I'll try it out, see how it goes. If it goes well, I can add more hours. If no one shows up, then I won't. But I think that's what I'm shooting for. This weekend's too soon. I haven't even looked at the papers yet. All right. Anything else in your minds? Yeah. 10 out of 10. This is his first year, by the way. I know you. If you knew Dean Gooder, I don't think you did. Maybe just briefly. But yeah, this is his first year in the building, which is ridiculous. I think that to do. But that's where we are. Let's resume our discussion of Dred Scott. And I got a lot of really good questions in the minute poll last class. I wish I could go over them all, but I can't. I'm sorry, there's just not enough time. But I did read every one of them, and I do appreciate the thought you put into it. And I think there was a very wide range of reactions. Some people were, I think, very despondent, right? They were just, I don't want to say sad, because sad is such just like an emotional word, but they felt dejected, maybe that's a good word, that, this sort of opinion could be in a, Supreme Court case that's so dehumanizing and wicked, whatever word you want to use, to just demean a person as just this piece of chattel, this article of commerce. And I agree, I'm with you. It's a hard case to read, and I try to approach it as with as much sensitivity as I can. But I don't think there's any amount that can do justice to it. I mean, we have cases like Korematsu and Dred Scott, and we'll do some other cases involving eugenics that are just hard to read. They're gonna hit you where it hurts. This is a sort of class where things are going to offend you. Things are going to upset you, and I can't make any promise around it. That's just the nature of our topic. When I teach torts or property or contracts, the cases are pretty boring, right? I mean, let's be honest, right? Who actually cares if a covenant runs with the land? Does anyone actually care? No one actually cares. Does anyone care if it's an easement in gross? No one actually cares. But this is stuff that I think people care about. Other comments were, they were surprised at how the Constitution itself sort of avoided the slavery issue, right? A number of students wrote that they'd always just kind of assumed that slavery was sort of built into the Constitution in very express language, and they were surprised that it wasn't. That they used these sorts of references like other persons, or persons held to persons held to labor or service, or such persons, right? And people were just surprised by that, because that's generally not what you're taught in school, which is fine, right? People, there's a lot of history to cover. Some people were also, I think, surprised in the comments that by the time you got to the 1780s and 90s, slavery was sort of on the downswing, because it wasn't necessarily moral, but it was considered just not very economically viable. Then we talked about the cotton gin. This was this invention that made it easier to clean cotton, right? When cotton comes from the ground, it's a crop. There are these seeds in them, and these very sticky seeds. And if you have to sort of scrape them out and pull the seeds, and it's not very, it's not an easy process to do by hand. And in the 1790s, you had this cotton gin, which was a very important invention that made it easy to pull the seeds out and make cotton useful for linens and other product. And that really altered the dynamic. So from the 1790s to the 1800s, you had this strong movement to expand slavery, and indeed create an ideology whereby slavery was not just legal, but just or moral or defensible, right? This was a good thing to have, not just it was, we were embarrassed. They thought it was a good idea. And this really shifted in the 1790s to 1800s and the early 1810s and so on. But yeah, there were a wide range of comments. I think those were the sort of primary heads, and I just wanted to flag those. So thank you for those comments. If I see, 2 or 3 students write the same thing, they know it's something I should probably talk about. That's my rule of thumb. Laura asks in the chat, did we get an answer for the poll question number 1? I think that's false. I don't think the Constitution of 1787 excluded people from excluded slaves from citizenship. It said nothing at all. It was completely silent, and that was very deliberate. The concept of citizenship was largely left to the states. There wasn't this concept of national citizenship. So I don't think it said a word. I think you could read it that way, that excluded slaves, but I don't think that's what the text actually says. Thank you for the question, Laura. All right. Questions on what I just said, those 3 things, the sort of that people had to take away from last week. I do read those questions. I read the minute polls very carefully. I actually find them it's a very useful thing. Even if we go back in person, I think I'll still do this because it really gives me like an instant gut check of where we are. Yeah, Douglas, go ahead.
I was just wondering what you think a Thomas dissent would have been like in Dred Scott, or if there would have been a dissent.
You mean Justice Clarence Thomas?
Yes.
Oh boy. Well, I don't think he would have been in the Supreme Court in the 1850s. That's for damn sure. I think the dissents from Justice McLean and Justice, the other guy I'm blanking on. I'm embarrassed. Curtis, thank you. Yeah, I'm sorry. Thank you so much, whoever just said Curtis. Thank you. Yeah, Justice McLean and Justice Curtis. I thought they were pretty good. Agree or disagree. I thought they were pretty, persuasive. But even even if you don't agree with what Curtis McLean wrote, the fact that there were judges at this time who saw things differently was significant. You know, you have a lot of cases this semester where there's an 8-1 vote, right? Where there's one dissenter. And the dissenter is like you know, we're not all like Tawny, right? We're not all like the majority. We just, there is disagreement in this time. Some of the hardest cases for students to grasp are the 9-0s, where there's no written dissent. Because you can't even know what people at that time thought the other answer was. So I think the dissents there are quite good. You know, I'm sure they say things that maybe aren't exactly right, but I think they get it across. You know, Justice Thomas, you know, I think he would... we'll get to Justice Thomas quite a bit. His views on race are not what you might expect. They're different. And when we do the affirmative action cases, I think we'll see that. But I'll save Thomas for later. But yeah, he dissents in everything. He always does. All right, let's take a look at a question, please. Let me give you the link for the chat. I'm sorry. For the class notes. All right, so let's take a look at question number 1. Let me get the software up. Class. Okay. So the first question I want you to guys answer is this, right? Dred Scott is consistent with the original meaning of the Constitution. True or false? Someone still has their microphone open. Oh, is that Moses? Did you have a question?
I did, because I'm asking myself, how am I supposed to answer this question? Morally or by Dred Scott?
Ooh.
So that's actually why I unmuted myself.
All right, well, how about this? I'll call you in a second when everyone finishes with their answer. Is that okay?
What'd you say?
Can I call on you in a second to answer this one, or at least you tell me what you think?
Oh, sure. Oh, boy. Okay.
All right. All right, maybe another 10 seconds. Ooh.
This would have been better a short answer.
You know what? Do you want to make it a short answer? I can do that. All right. I'll take
Not
it.
at this point. You can do it for the next class.
Oh, God. All right, well.
We have to discuss it. Moses is going to lead us.
Moses will lead us. I love that imagery, by the way. And actually, Joshua follows Moses. I guess that makes sense. Sorry. All right. Go watch the 10 Commandments. All right, Moses. What are you thinking? How are you approaching this one?
So, I asked the question of how am I supposed to answer this question, morally or by what the decision says, if I'm going to go with precedent, you know? And so I ultimately answered with precedent. But this is striking at the personal core. And that's where I say silent. You know, in essence, I agree with you that it's silent. But going with precedent, I just simply said true.
Which precedent? Which precedent you talking about?
I answered it from a modern precedent standard. That's what I mean by that, by precedent, not necessarily by what happened before 1857. I mean, obviously, I go with, you know, the Curtis dissent and the other dissent. I mean, so I don't think personally or morally that it was consistent with the original meaning. But today's case is going to say that it was consistent.
What do you mean today's case? I think I'm just not sure what you mean. I'm asking in 1857, right? Just forget 2020 for a minute. We don't know what happened after Civil War, right? In 1857, which opinion, the majority or the dissent, do you think had the better of history? Had the better take on history?
I think the dissent did. The dissent handled the complexity of the questions that were going on at that time in terms of, you know, there were free African Americans voting and participating and owning property and doing all the things that one does under life, liberty, and the pursuit of happiness. Mm-hmm. So those things were happening in some of the northern states. I mean, hell, there's some of them happening in the southern states too. That's a whole other issue. So there are African Americans participating in the citizenship process at that particular time, at the time of the Revolution, at the time after the Revolution, at the time after around the time of the Constitution. Mm-hmm. So I think the dissent handled the debate that the founding fathers had. The dissent handled it a little better than I think Tawny did. Tawny just oversimplified it.
Oh, I think so. But what do you mean by today's precedent? So I think I know what you're getting at, but I want to just drill down if I can just a little more. What do you mean by today's precedents?
Oh, you mean when I answered the question? Or
Yeah.
I think stare decisis, that whatever's been decided has been decided, So I threw that today's standard, what we talk about obviously at school, I threw that back into 1857 to answer the question. Mm-hmm. Even though I knew it was so that's what I did. That's kind of the wicked stuff I did in my head.
Okay, that's fine.
And then obviously the court, in the 1870s, the court will build upon.
Oh, I see what you're saying. So you're saying that the modern precedents have basically adopted Tawny's understanding of original meaning. Is that what you're getting at?
Yes.
That's it. Okay, perfect. That's exactly what I thought you were getting. Let me try to rephrase. Let me just try to rephrase, and you tell me if I got it right. There were Frederick Douglass, through all these abolitionists. They had their arguments, but Tawny sort of won out. And Tawny's conception of original meaning has become like what people think was original meaning. Is that sort of what your point is?
Yes.
Oh, okay. That's an excellent point. Thank you so much, Moses. I'm really glad you put it that way. I thought you were getting there, and I just wanted to just make that point clear. I think Moses raised a really solid point here. A really solid point. Tawny is not, how do we put this? Faithful to history, right? He plays fast and loose, right? He focuses on facts that are in his favor, and he sort of ignores facts that cut against the argument, right? For example, in this period, the northern states allowed the freedmen could vote. They were allowed to own property. They were allowed to go to school. They were allowed to vote. They were allowed to do a whole host of things in this period. And that just cuts against Tawny's entire thing about the unfortunate race, right? He's not right. But Tawny created this image of the Constitution as a pro-slavery document. And the irony is that the people most likely to adopt that view today, which I think is what Moses was getting at, are those who are in favor of racial equality. In other words, people today, they don't realize it, but they're adopting the Tawny view of the Constitution as a way to say the Constitution is a failed document, that it was born with this embedded inferiority. And because it has this history, it's not a good document. The Tawny argument wasn't new. There was a very famous abolitionist, someone who opposed slavery, who said the Constitution was a deal with the devil. His name was Garrison. You can read about him in the book if you want. Garrison actually had a famous speech where he said the Constitution is a pact with the devil. Because he opposed slavery. He opposed it. But he said this is an evil document. And he actually lit the Constitution on fire. He actually titled, the little pot Constitution, he actually put it on fire. He said this is an evil document. And it's one of these weird ironies of history that the abolitionists, the Garrisonians, agreed with Dred Scott's history, right? They agree that this document is evil. But then you had other abolitionists who did not agree with Garrison. Frederick Douglass, who's probably the most famous abolitionist, what a remarkable person. He was a runaway slave. He educated himself. He traveled around the world speaking about abolitionism. Remarkable human being. Very complex. I don't want to try to summarize. He had a very complex worldview, and I can't do justice to it here. But he was a remarkable person. Douglass disagreed with Garrison, and Douglass said, no. The Constitution is a good document. It says nothing about slavery. And Douglass said, we look at the Declaration. The Declaration says we're all equal. Okay, maybe we didn't do it right away, but we're working towards it. And so you had this sort of the Frederick Douglass wing that said the Constitution is an anti-slavery document. It doesn't even refer to it. And you have the Garrisonian wing, which says, no, this is a deal with the devil. The southern states and northern states, they made a deal with the devil. They should not have made this deal. In fact, the Garrisonians basically wanted a civil war with the North. They wanted the North to secede. They thought that slavery was so evil that the northern states should separate so that they're not part of this pact. Right? It wasn't just the Southerners who wanted to secede. It was Northerners who wanted to secede. It's almost it's not the history lesson most people are taught. It's a very complex history. Okay, so then we get to Dred Scott. Then we get to Dred Scott. It was 1857, and we're right on the cusp of the Civil War. We don't know that yet, but it happened 3 years later. And Tawny goes and he says, "Well, you know what? We have the Frederick Douglass argument, and the Garrison argument. The Supreme Court's going to endorse Garrison, right? The Supreme Court's saying, Frederick Douglass, you're wrong. Douglass, you're wrong. The Supreme Court says Frederick Douglass is wrong, and then Garrison's right." And that just signaled a lot. When the Supreme Court endorses an argument, that has a has a weight, right? That's a significance. It's not just politicians arguing stuff. There's actually a Supreme Court saying, nope, this is a document that was born in slavery. This is a document that endorses inferiority to races, and that more or less signaled there was not time for reconciliation. That this maybe this was a deal with the devil. As Garrison said, maybe you should light the Constitution on fire. And then we had a Civil War. And Lincoln took extraordinary steps. He took extraordinary steps to try to preserve the Constitution. Because Lincoln agreed with Frederick Douglass. Lincoln did not agree with Roger Taney. Right? So again, you have Douglass and Lincoln, right, who said, no, this is a document that allows equality. And then you have Garrison, you have Dred Scott, and you have the Southerners saying, no, it's a slavery document, right? And you have this debate over what the meaning of the Constitution is. So this question I put to you, number one, is not an easy question. I'm not going to give you a right answer. There isn't one. I don't even want to pretend there's a right answer. There's not. Maybe Laney's right. Maybe there should be a short answer. Maybe I'll try that next year. I think that's a good suggestion. But there's no right answer here at all. There was a vigorous debate, and I don't ultimately care which side you pick. It's not important to me. I want you to see the different positions. You have the Lincoln, Frederick Douglass position on one side, right? You have the Garrison, Roger Taney position on the other side. And even today in this debate, right, there's a never-ending series of debates about the Constitution and whether these are a bunch of slaveholding white guys, and how do we respect their views? And these views, right? You can see them in popular debates all the time. But even at the time, the 1820s, 30s, 40s, 50s, people debated this exact question. There's nothing new. And if ultimately you say Roger Taney was right about history, then that's your position. If you say that that Frederick Douglass is right, then that's your position. But I want you just to see that there were these two sides of the debate, and we can't simply presume that the handiwork of the framers was this pro-slavery document, that there's positions on both sides. Randy and I are actually doing a book, I think I mentioned this, on slavery and the Constitution. So this is a lot of the sort of history that I'm trying to give. Because I think in modern culture, it's a very one-sided issue. These were complex times. Even among those who opposed slavery, they didn't agree. Right? Garrison opposed slavery with his passion. Every ounce of his fiber was opposed to slavery. He actually wanted to secede from the Union to eliminate slavery. Garrison helped give Frederick Douglass a job at his newspaper. He helped to bring Frederick Douglass into the world of abolition. So he helped to develop him. So these were good friends. But Douglass and Garrison had a falling out. They had a huge fight because of this question. because Douglass would not go along with burning the Constitution. He said, I cannot do that. He would not do it. And then so Douglass and Garrison, they split. They separated. But they were very close, and just even allies in the fight against slavery couldn't agree on this question. All right. Lainey, I see your hands up.
So, do you see, or am I not wrong in seeing Chief Justice Roberts following the Tawny approach? Here's the answer I want, and now I'm going to weave my way through everything and show you how it works.
Oh, man. You just compare Roberts to Tawny. I've done that before myself. Oh, boy. Oh, boy. Well, let me answer your question this way. I think a lot of judges do what you're describing. I think there are a lot of judges who have an end goal in mind, and they sort of write an opinion that touches all the points they want to get to the answer they want. I don't think that's limited to John Roberts or any Chief Justice. I think a lot of judges engage in that sort of behavior. What I would say about Tawny, though, is he's really blatant about it, right? This is not saying that, a penalty looks like a tax. I mean, look, I can say it's wrong, but it's in the ballpark, right? Tawny is proactively reducing an entire race to chattel, right? And he does so by ignoring history in which these people were allowed to have citizenship, allowed to have voting, allowed to have rights. So I don't think the analogy holds in this case. I think it's unfair.
I was not suggesting Chief Justice Roberts is evil. I was just talking about the process to get to the answer he wants. Yeah,
I think a lot of judges do that. It's you'll see a lot of decisions this semester where the reasoning doesn't hold up, right? Where you read it's like, wait a minute, that doesn't make sense. There are steps 1, 2, 3, 4, 5, but you skip steps 3 and 4, and you just jump to 5, right? And you're going to see that this semester a lot, especially in the second half of the class. We're going into some murky water soon, my friends. And one of the reasons why a dissent is helpful, like Justice Curtis, is it points out the flaws in the majority. And then when the majority can't respond to the dissent, it's, think of like a boxing match where one side throws a punch and the other one just sort of falls down. They don't get back up and punch back. It means the first side had the better punch, right? If you can't return fire, so to speak, that means you don't have a response. So when you have these cases with strong dissents, like the Curtis dissent, I think, and Tawny really just says nothing in response, it's almost like a tacit admission that you don't have a response. Which is why I think the dissents are so powerful. This is Justice Ginsburg put this, I think, in a very sharp way. She said, dissents speak to future generations that will see things differently. I think that's the way we're looking at it, right? You're not writing for today's generation because you're in the dissent. You lost, right? The majority was whatever it was. But the dissent is speaking to some point in the future that may approach the thing a little bit differently. Right, you're speaking to a different time, and really, look, we're 160 years from Dred Scott, and we're still reading this dissent. I think it's significant, right? How many opinions were written in 1857 that we have no idea what they were? I mean, I don't even know, right? But this one we're still reading 150 years later, precisely because it spoke in a language, in a tone that transcended its time, which is why I think we have it. You'll see this when we do the Plessy case next week, which was a separate but equal case. Justice Harlan's dissent, we're still reading 100 years later, 120 years later. And people will be reading 120 years from now. Right? It's going to be there. Elaine, I didn't mean to insinuate you were comparing slavery and Obamacare, but I know what you meant. I just wanted to make sure the point was clear. Raymond says we're too critical of the Chief Justice. Probably. Guilty as charged. I used to be more critical of Justice Kennedy. That sort of passed. Now I'm critical of Roberts. Next to me, Kavanaugh next semester. So now we have 15 justices, so who even cares? It won't even matter. Imagine putting your outline together like an 11-member court. It's going to be very complicated. All the extra dissents you have to read. All right. What else? Yeah, these are complex questions. They're not easy questions. And I think you guys are doing a very good job with these issues. All right. What else? I do want to move on to today's material eventually. Anything else? Yeah, Moses says it'd be easy to have a simple opinion, but who's being left out is the difficulty. Yeah, these are really complex cases. They don't get easier. The second half of the semester is so different than the first half. I really wish there were different classes. I feel like I have to be a different professor with the second half. It's completely different. If you notice, I'm approaching it differently. I don't use the same sort of structural arguments. It's just a different world. That's common law. All right. I do want to let's skip question number 2. I don't have time for it. Let's do question 3. I'll skip question number 2. Just I don't have time. Was the Lincoln administration bound to adhere to Chief Justice Tawny's opinion about citizenship in Dred Scott? This is actually a significant question that would come up later. Okay. Alrighty. I don't even know who I'm up to. Who's next? Because Moses volunteered.
It's me.
Who's that? Okay, Seth. So Seth, let me ask you just a question before we look at this one. I'm sorry, I highlighted the wrong person. Sorry, I thought I didn't mean to highlight you. Seth, let me ask you this question. What does it mean to be bound to a decision? What does that mean?
You're required to follow it.
And generally, forget common law. Just CIVPRO, right? Who's bound by a judgment?
Everyone.
So if I sue you, is Douglas bound by that judgment?
Oh, I thought you meant, okay. Just the parties to the suit.
Okay, just the parties to the suit, so the plaintiff and defendant, right?
Or those closely, I guess, associated with
can you be bound by a lawsuit in which you were not served process and not given a chance to defend yourself? So if I sue you,
I don't remember.
Let's say you're doing something wrong, right? Let's say you're creating a nuisance, right? And I get a judgment against you, and then Douglas over there does the exact same action, committing a nuisance. Is he bound by that judgment?
No.
Why not?
Because he's separate.
Yeah, look. This is CIVPRO, right? What's the very first thing you learn in CIVPRO procedure? You have to give a person notice, right? You have to give them service of process, right? You have to sue them. They have a chance to defend themselves. Maybe Douglas has a defense that you don't have, right? Maybe Douglas has an excuse, right? So the most basic principle of litigation, this has nothing to do with common law, is judgments are limited to the parties, right? If I sue Seth for some law, whatever, nuisance, whatever, and Douglas does the same thing, I have to sue Douglas separately, right? We can't say, hey, Douglas, you're bound. Now, Douglas is a smart guy. I'm just picking because he's in my Zoom window next to you, right? Douglas is a smart guy. If he knows that I sued Seth for something, what might Douglas do, Seth? Let's start this again. If Douglas knows that I just sued you, Seth, what might Douglas do voluntarily to avoid problems?
Change what he's doing.
Yeah. Is that by force or voluntarily?
Voluntarily.
Okay, very good. Thank you, Seth. Right. So the way litigation usually works is you have these two forces, right? You have a binding judgment, which binds the plaintiff and defendant. But you also have precedent, right? Where if I know there's some court precedent saying that this is a nuisance, you can't do it, I'm a reasonable person. I'm going to stop doing that, right? I'm not going to engage in conduct that's going to get me sued. So we don't have lawlessness. Generally, people say, well, if the court rules, maybe I should, follow that ruling as a matter of stare decisis. Right? I don't have to, but I should. The analysis is the same with the Supreme Court, right? The Supreme Court is called supreme, but it's not actually supreme, right? The Supreme Court's judgment binds the parties before it. So in this case, it was Dred Scott and Sanford. Scott was in Missouri, Sanford was in New York. Lincoln came along, and Lincoln said, well, you know what? I think Dred Scott's an immoral decision. It's wrong. It butchers the Constitution. The Constitution does not reduce these people to mere chattel, to articles of commerce. These are human beings. Lincoln says, I agree with the dissent. I agree with Justice McLean. I agree with Justice Curtis. So what happens when Lincoln becomes president? He instructs his administration to say, you know what? We're not going to follow Dred Scott as precedent. The case didn't involve the federal government. The federal government was not a party to the case. Therefore, we're ignored. So Lincoln did things. For example, he granted passports to freed slaves. That was a huge deal because it's an express recognition of citizenship, right? A passport. You have a passport in your hand, you're a U.S. citizen. And he granted passports to the freedmen. That was a huge deal. It was basically putting a thumb in Roger Taney's face, saying, nope, not going to do it. Lincoln's Secretary of War admitted runaway slaves to the Union Army. And they said, if you're a runaway slave and you're in the Union Army, you'll be given citizenship, as will your family. Second remit, I promise. Lincoln's perhaps most significant action was the Emancipation Proclamation, which unfortunately I had to cut from this semester. I usually do a lesson on it. I have to cut so many things, and I'm sorry, it breaks my heart, but I'll discuss it to you a little briefly. The Emancipation Proclamation is well known. If you ever go in Houston to Emancipation Park, it's named after the Emancipation Proclamation. The Emancipation Proclamation freed some slaves, not all slaves, but freed some slaves. Specifically, it freed the slaves in the Southern rebel territories. It did not free the slaves in the northern states. Slaves in the northern states? Oh yes, my friends. There were states in the Union that allowed slavery. Maryland, Kentucky, they're called the border states. And Lincoln basically said, we need these states in the Union, we can't survive without them, so they can keep slavery. Again, these were complex times, I'm not trying to minimize it. But there were northern Union states that were pro-slavery. So it wasn't a sharp divide, as you may think. But Lincoln emancipated the slaves, which was directly opposite of what Tawny suggested. Right? So in case after case after case, Lincoln was like, "Whatever, Tawny, you did you. I'm going to do my thing, right? You're not going to control me." So the answer to this one, I think, is false. And about 80% of you got this one right. But it's a significant move for a sitting president to say to the Supreme Court, "Yeah, you made your ruling. That's nice. That doesn't affect what I'm doing here." Raymond, go ahead.
This was on the Emancipation Proclamation. Was
Sure.
that not a seizure of property? I thought it was. So he was adopting Tawny's viewpoint. Was he not?
Yeah, okay, you can make me do this. I will. That's fine. All right. The legal basis of the Emancipation Proclamation is not pretty. People like the outcome, but not the reasoning. Okay. So at the time, under Dred Scott, slaves were owned by the South. They were by plantation owners, owned by whatever, right? They were owned. They were considered property. That was what Dred Scott said. In a time of war, the military can seize property. So I'll use a very simple example. Right? Let's say that there's a Union army comes across a warehouse of ammunition, of gunpowder. At that point, the general could take over the factory of gunpowder, what's called a requisition, and use that gunpowder for its own purposes. Or let's say the Union army comes across a railroad and they decide to commandeer the railroad to move their own troops. Okay, you can do that. So here's what Lincoln said. Lincoln said, okay, Tawny, I'll see you and I'll one-up you. You said you said that slaves are property? Okay. We're going to seize that property. So effectively, the Union Army seized, that is, took over all the slaves in the rebel territory. And once that property was seized, the government said, okay, we're going to emancipate all of them. So the emancipation actually was premised on Tawny's ruling, but Raymond picked up on a very subtle nuance. After Lincoln freed the slaves, he then made them citizenship. That if they would join the Union Army, he would make them citizens. So he simultaneously relied on Tawny's understanding of property, but then flipped it and said, okay, but now you're citizens, which Tawny said you can't do. So Raymond, it was actually a little bit of both, right? You know, we make fun of Roberts over for like making these creative legal arguments. The Emancipation was one of those, right? This was a very risky legal strategy where he simultaneously said, yes, you're property, but I'm going to make you a citizen, right? Everyone just see what's going on here, right? It was very risky what Lincoln was doing. Morally just in every level, but just the legal argument is dubious, right? That if they're property, they can't be made citizens. But if they're citizens, they can't be property in the first place. Justice Curtis, remember the dissenter in Dred Scott? This guy resigned from the Supreme Court because of Dred Scott. He thought it was such an awful decision. Justice Curtis said the Emancipation was unconstitutional. I said again, Justice Curtis, the guy who resigned from Dred Scott, the dissenter, he thought Lincoln was acting illegally. Because they said, Lincoln, you can't do this, right? If you can't have it both ways. If Dred Scott gives you the basis to emancipate them, you can't give them citizenship, right? And if these people are not chattel, you can't emancipate them as chattel. So it's this very... look, Lincoln was a complex guy. These were not easy times. And Lincoln was an attorney. And he was making very carefully crafted legal arguments, as an attorney would, right? He said, look, there are these precedents. And I'm going to use them. So Raymond, to your question, did Lincoln rely on Tawny? The answer is yes and no. He did both in a very non-linear fashion. Does that answer your question a little bit? Raymond, did I confuse you more?
No, you did. Thank you.
Okay. If you want, usually when I teach Youngstown, remember the steel seizure case, I include a topic on the Emancipation Proclamation. It's in that chapter, and I had to cut it this semester because I just ran out of time. I have to cut stuff, and it was never a good fit because what you're going from seizing a steel mill to seizing slaves, it always felt like there's a connection. It always felt a little forced. So I said I can only cut it this semester, but maybe I should add it to this part of the semester. There's no one way of teaching common law. It's very hard. All right, any other questions on Dred Scott? Anything else on Dred Scott? Yeah. I'm sure you're aware, but there's a movement involving statues nationwide, and one of the first statues that came down a couple of years ago was of Roger Tawny. At the Maryland State House in Annapolis, Tawny was a native son of Baltimore. They took down the Tawny statue in the dark of night, like 2 in the morning. They had a flatbed come out. No, not like a mob, but like just the state actually took it down, in the middle of the night with a flatbed. There was a movement to take it down, and this was in 2015 or 16, so a couple of years ago. So this is recent, but not that recent. And then they removed the Tawny statue. Recently, in the House of Representatives, there's a bust of Roger Tawny. It was outside the old Supreme Court chamber, right? Now the Supreme Court has their own building, but for the first 150 years, the Supreme Court met in the Capitol, and there was a bust of Roger Tawny right outside the Capitol Supreme Court chamber. And I think the House recently authorized to replace the bust of Tawny with Thurgood Marshall, who was the first African American justice in the court, which I think is a positive move. There's still a bust of Roger Tawny in the U.S. Supreme Court. They have in the Great Hall, if you've ever been there, busts of every Chief Justice. They have John Jay and John Marshall and all of them, right? And there's still a Roger Tawny bust. And like years ago, I wondered, will there be a movement to try and take down the Tawny bust in the Supreme Court? It might. Now, someone asked in the chat how many justices were slave owners at the time of Scott. I've looked into this before. Most of the justices appointed were Southerners because they were Southern presidents. So I suspect it was the majority of them. Tawny was a slave owner himself. I think at some point he did emancipate his slaves, but he still supported it. He had a lot in he was a very wealthy family in Maryland. I just do want to flag this point. Do you know who was a huge slave owner? John Marshall, the great Chief Justice. There are currently 3 law schools in the United States named after, actually 4 law schools named after John Marshall. 2 of them are thinking about dropping the name John Marshall from the name of their schools. There's John Marshall Law School in Chicago. There's also a Marshall Law School in Cleveland. There's 2 others. There's one in Atlanta, and there's one in William and Mary. It's called the Marshall White School of Law. Marshall went there. That was his law school. It was named after him. And years ago, I told a reporter for the New York Times, I said, if Roger Tawny statues come down, what about John Marshall statues? Because he was much more pro-slavery than Tawny was. Also, he had some pretty bad opinions, which you may have read in other classes. So, yeah, you'll see it. It'll spread. All right. Anything else in Dred Scott? Yeah, Laney, go ahead.
When you talk about the anti-canon cases, is that something we just talk about, or is there a way that the court makes it an official anti-canon case?
No, this is law professors talking, unfortunately. It's not a real thing. Right? I mean, the court... Oh, actually, this is a good segue. Who's next? Hold on. Who's next? I lost track. I'm sorry.
I'm next.
Smia, thank you. Smia, let me ask you a question, please. Did the Supreme Court ever overrule Dred Scott?
No.
So is it still good law?
It's not good law because it was repealed by the passing of the 14th Amendment.
How does that work? How does an amendment overturn a Supreme Court case? Does the amendment say we are hereby overruling Dred Scott? Is that what's in the amendment? Does it say that?
No.
So how do you know an amendment overrules Dred Scott?
Well, in this case, the 14th Amendment was passed in response partly to Dred Scott.
No, you're right about that. But how do you know that the Reconstruction amendments overruled this case if it doesn't say so?
Because they basically... I know this.
It's okay.
because what they were saying was in direct
Good.
opposition of what the case was saying, or what the case ruled.
Good. Very good. I think I was looking for. Thank you very much, Miha. That's right. So let me briefly summarize the history, because I could teach an entire semester on just the period between Dred Scott and the Civil War and the Reconstruction. I could teach an entire semester on that 10-year window. Dred Scott was 1857. After the decision, Lincoln rose to national prominence as an attorney, attacking the Dred Scott case. And he kept saying, look, Frederick Douglass is right. The Constitution is not a pro-slavery document. And he founded a political party. He didn't found it, but he was the leading figure of a political party. It was the Republican Party. And the Republican Party was formed as an anti-slavery party. That was the core that united them to oppose slavery. And in the election of 1860, Lincoln was on the ballot as Republican. And there was basically a three-way split where Lincoln won the majority of the Electoral College, but he didn't win a single Southern state because he was opposed to slavery. After Lincoln was elected, the Southern states began to secede. Or at least that's what they said. According to Lincoln, there was never a civil war, right? Lincoln said, no, there's not a civil war. There's just rebellion. That's why they call them rebel states. There's just rebellion. Lincoln did not want to even suggest the Constitution could be violated, because the Constitution doesn't allow secession, Lincoln said. He was very much about making constitutional arguments. It's remarkable, how much he tried to ground himself in the Constitution. He was very, very adamant about this. All right, so what happens? The states begin to secede, as they said. And then Lincoln prosecuted this war. There was no declaration of war. Why? To declare war on another country is to agree there's secession, right? The United States never recognized the Confederacy as a separate country. So there couldn't be secession. There could be a declaration of war. And instead, Lincoln relied on his own executive powers to keep the Union whole. Lincoln said a house divided cannot stand, right? He needed to keep the Union together. He took severe steps to prosecute this war. One of the steps was the the Emancipation Proclamation, where he freed slaves and they guaranteed them citizenship to fight in the Union Army. Finally, the war started coming to a close. It was a bloody, bloody war. And in 1865, we get the enactment of the 13th Amendment. Did anyone see the movie Lincoln? Came out maybe 4 or 5 years ago. I didn't like it. You would think I liked a movie about a constitutional amendment, but I just thought kind of, it dragged. It could have been done better, but whatever. But the movie tells the story of how the 13th Amendment was ratified. Now, I want you to look at the text. Let me just share my screen for a moment. I want you to just look at the text of the 13th Amendment for a minute. There it is. Okay. The 13th Amendment was ratified in 1865, so right after the Civil War drew to a close. It says, neither slavery nor involuntary servitude shall exist within the United States. This was an express repudiation of Dred Scott. Dred Scott said that slavery was baked into the Constitution, right? That the Constitution was born as a pro-slavery document. That's what Garrison said. The 13th Amendment, though, embraces Frederick Douglass. Right? The 13th Amendment says, no. We are now adopting Frederick Douglass' position to say that slavery cannot exist within the United States. Not just the government can have slaves. Anyone. It shall not exist anywhere. This is a restriction on private conduct. That was significant. Okay? Now, focus on these words. Neither slavery nor involuntary servitude. Slavery nor involuntary servitude. You might ask yourself, Josh, what's the difference between slavery and involuntary servitude? Right? The text suggests they're different things. Right? Well, you say, well, what about an indentured servant? Well, that was kind of voluntary, right? An indentured servant was when you volunteer to be a slave or a servant for a number of years, and then after the 10 years over, you become a free man. Involuntary servitude is what you might think of chattel slavery, where a person had no choice, that they were bound for service for life, that their children would be bound to service, that their grandchildren would be bound to service, right? With slavery, there was no choice. You were not a volunteer, so to speak, right? You were stuck, your kids were stuck, your grandkids were stuck. So if involuntary servitude describes the fact that you're bound to labor, what is slavery? And this is a concept I think is hard to understand today. Slavery did not just refer to being physically bound to labor, right? That's what involuntary servitude was. Slavery was something bigger, was something more than merely being bound to labor. Slavery is often described as an institution. And that phrase institution doesn't really mean today what we think it means back then. But it described as an entire system by which this sort of racial inferiority was established by the state, by private parties. Right? In other words, slavery wasn't just limited to physical bondage on a plantation. Right? Slavery was limited, right? Slavery was broader. Slavery extended to the entire system of creating racial inferiority. It was economic. Free blacks couldn't own property. It was political. They couldn't vote. Free blacks couldn't bear arms. You couldn't own weapons. You see this in the Cruikshank case, right? They couldn't serve on juries. The concept of slavery was just much broader than mere involuntary servitude. And I focus on this point extensively because I think it helps to explain what happens later. So we have Section 1 of the 13th Amendment says no slavery, no involuntary servitude. Okay. But Congress didn't stop there. Congress added Section 2, which says Congress shall have the power to enforce the article by appropriate legislation. What does that mean? That Congress can enact statutes, laws, that enforce this article. What does that mean? To ensure that there's no slavery. Right? The Republicans didn't trust the Southerners to just say, okay, cool, we're going to get rid of slavery, right? Excellent, right? Everything's going to be awesome, right? No, come on. That's not right, right? They didn't trust the Southerners to actually do that. They said, we need to put some teeth into this. So, after the 13th Amendment was enacted, Congress got down to work. And they passed a very important statute called the Civil Rights Act of 1866. the Civil Rights Act of 1866. By the way, this history is in the 100 Cases book. We have an entire chapter on it, but I'm summarizing it for you. And the Civil Rights Act of 1866 granted specific rights to the freedmen. Okay? It granted them specific rights. That same year, Congress enacted also a law called the Freedmen Bureau Act. The Freedmen Bureau Act. Freedmen was just an expression for freed slave. That's what they were called, right? The Freedmen's Bureau Act. And this was basically a federal agency that was designed to help the freedmen come back into society. These two statutes passed the House and Senate. They were given the freedmen the right to make contracts, to be parties, to give evidence, to inherit property, to sell property, the right to bear arms, the right to have freedom of assembly. It guaranteed these various privileges and immunities to the freedmen. This was a phrase that was known, right? Privileges and immunities. It's not a word we use today. But these were these sorts of rights that were so important that they could not be taken away. Privileges and immunities. That was the phrase used. Now, President Lincoln would have happily signed both bills. Unfortunately for President Lincoln, he was not around to see those bills. He was assassinated. And the vice president, Andrew Johnson, became president. Johnson was a Confederate sympathizer. He was opposed to Reconstruction. And Johnson said, no, I'm going to veto these bills. I'm going to veto them. Congress doesn't have the power to do all these things, right? Johnson said, nope, the 13th Amendment was just about limiting chattel slavery and nothing else. So you see, with even a year of the end of the Civil War, there was a debate about what slavery even meant. We're debating this question now 150 years later, right? What was slavery? A year later, the president goes ahead and vetoes the Civil Rights Act and the Freedmen's Bureau Act because he says Congress doesn't have this power. All they can do is get rid of actual chattel slavery. They can't get rid of these various incidents of slavery, or what we call the badges of slavery. Congress was all Republican, and they overrode the veto, so that was easy. But Congress recognized that Johnson may have a point. They didn't want to say that too out loud, but they said, maybe he's right. Maybe we need something more than the 13th Amendment. Maybe the 13th Amendment can't support these bills. So as a result, Congress then begins to ratify what will become the 14th Amendment. And let me walk you through it one step at a time. The 14th Amendment has 5 sections. In this class, we will only focus on sections 1 and 5. I won't talk about sections 2, 3, and 4. You can look them up. They're just not relevant to our studies. But section 1 and 5 are really important. Let me walk through them one at a time. Remember, Dred Scott said that people of African descent could never be citizens. They were an unfortunate race. They could never be citizens ever, ever, ever. Before the 14th Amendment, the Constitution was silent on who is a citizen. Okay? It was silent. That would change. So Section 1 of the 14th Amendment begins: all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and the state wherein they reside. This is what's known as a Birthright Citizenship Clause, or just a Citizenship Clause. This kills Roger Taney's thesis. It says, if you're born here, you're a citizen. And you're not just a citizen of your of the United States, you're also a citizen of your own state. So if you're born in Georgia on a plantation, guess what? You're a citizen of the United States and you're a citizen of Georgia. Even if you were born into bondage. This is retroactive. It's not just born in the past. That's our born in the future. It's people who are already born. So this immediately grants citizenship to all the freedmen, immediately. Which was a huge deal. Section 1 did what the Emancipation Proclamation could not do. Right, the Emancipation Proclamation gives citizenship to a very small number of freedmen. This gave it to everyone. And not just freedmen, right? It says all persons born, whether you're a slave or not. Not every country has birthright citizenship. In fact, in Europe, to be a citizen, generally your parents have to be citizens. It's actually, the United States is an outlier. Well, not outlier, but generally in the European continent, they have citizenship through parents. And generally in the Americas, it's birthright citizenship. That's just how history went. All right, any questions so far on the citizenship clause? All right, let's move on. The second sentence says, no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. This provision is known as the Privileges or Immunities Clause. Now, so far in the Constitution, virtually all the restrictions were placed on the federal government. But this restriction is imposed on the states. The states cannot enforce any privilege or immunity of citizens of the United States. What does that mean? We'll get through and do Slaughterhouse, right? But at a minimum, there's certain rights that the states cannot violate. What those rights are, we'll get to in a few minutes. The next clause is the famous due process clause. We will spend probably 5 or 6 weeks on this clause. It says, nor shall any state deprive any person of life, liberty, or property without due process of law. We'll spend a lot of time on this provision. Don't worry, you're going to hate it soon. But the important word here is state. The Fifth Amendment already has a due process clause. The federal government was already bound by a due process clause. But now the states were subject to a different rule, or subject to the same rule, I'm sorry. Then we get to the last portion. No state shall deny to any person within its jurisdiction the equal protection of the laws. The equal protection of the laws. Today, this clause is read to mean that people have to be treated equally regardless of their race, for example. That's not what the amendment says. It says equal protection. Protection. What does protection mean? Protection against violence. Protection of your rights. Protection from whom? The government? The Ku Klux Klan? Right? Lynch mobs? This is a provision we'll talk about in a week or so that the meaning has sort of faded. But the key word there is not necessarily equal, but protection. That's the focus of how can the state protect you? And what are they protecting? All right, and then we get to Section 5, which is almost identical to Section 2 of the 13th Amendment. Again, you have Section 2 of the 13th Amendment, which gives Congress power. And then you have Section 5 of the 14th Amendment, which gives Congress power to enforce. In common discussion, if I say Section 5, I'm referring to Section 5 of the 14th Amendment. We call it Section 5. It's also called the Enforcement Clause. The Enforcement Clause, which allows Congress to enforce the 14th Amendment. Specifically, if a state is denying someone equal protection, Congress can intervene. If a state is depriving someone of the due process of law, Congress can intervene. If a state is depriving someone of their privileges or immunities, Congress can intervene. The 14th Amendment was not designed to be a judicially enforced provision. It was designed to be a congressionally enforced provision, that Congress would be in the driver's seat and that Congress would ensure that everything was good, that people's rights were being respected. We'll spend the rest of the semester on the 14th Amendment. I'm not joking. Basically, the next 12 weeks, or sorry, the next 12 classes or so, all the 14th Amendment. Questions on the 14th Amendment? Of course you have questions. A lot of liars, but it's fine. I want to mention just briefly the 15th Amendment because I will not have time to come back to it. But a couple years after the 14th Amendment was ratified, things started going downhill already. It happened very quickly. And many of the southern states began to disenfranchise their freedmen. They wouldn't let them vote. They would contrive these different schemes, the so-called grandfather clause and the poll tax, these various schemes to keep them away from the ballot. People find this hard to believe, but in the period after the 14th Amendment, African Americans were sent to Congress. I think his name was Hiram Revels, was a senator from Mississippi. Mississippi sent a black man to Congress, which was stunning. A couple years after the Civil War, it's remarkable to think about that in context. If memory serves, his colleagues wouldn't even look at him; they wouldn't even talk to him. Right? He was just being treated just like this outsider. But he had a voice and a vote. He was allowed to vote. But things started going downhill really quick. And the southern states began imposing the Jim Crow laws. These were racist codes to try to reinstitute slavery, not formal slavery with the chattel slavery, but this sort of inequality. So the Republicans in Congress tried one more time to pass the 15th Amendment to try and get things under control, which says that the right of citizens to vote shall be denied on the basis of race. This would have very little teeth. And indeed, the states began to impose even more rigid requirements on who could vote. So the story of the Reconstruction Amendments is one of great hope and potential that was stifled very quickly. It was stifled by the Supreme Court. The hope was stifled by the southern states. And eventually the hope was stifled by the executive branch, which was not willing to alter the status quo. Right? Okay. All right. Questions so far? Nothing? Really? I just threw a lot of stuff at you. There's a lot there.
I'll ask a question.
That's fine. Go, Tori.
Okay, just real quick, with the involuntary servitude and all that goodness, neither slavery nor involuntary servitude shall exist within the U.S. Aside from being duly convicted, wasn't that just a pass to round up black people, arrest them, and then force them back into slavery? I feel like that was a pretty big loophole. Yeah, so let me go back to the text. I think Tori raises a fair point. It says, where is it? It says, let me hold up. It says, neither slavery nor involuntary servitude, except as a punishment for a crime where the party was duly convicted, shall exist. So forget for a moment what happened later, right?
is a prison a form of slavery? Just let's assume you're actually convicted of a crime. This wasn't like a bogus charge, right? You're basically being locked up in a room and you can't leave. I think there was a concern that if you had slavery, if you had the 13th Amendment, people in jails could argue that they were being held as slaves. And that's I think, a non-trivial concern. But Torrey describes what happened later. In the early 20th century, states began creating, pardon my French, bullshit laws, right? They were just bogus laws. So, for example, being unemployed was a crime. Breaching a contract was a crime. Vagrancy was a crime, right? These bogus laws that, they weren't real. And the purpose of these laws was basically to entrap people. Freed slaves, right? And arrest them, convict them for violating whatever the law is, and then, you're duly convicted, now we can put you in servitude. And they put you in a chain gang, right, where you're doing manual labor for X years, whatever your sentence was. So it wasn't like a lifetime conviction. Your kids wouldn't be enslaved, but it was a way of imposing slavery. There's a case in your book, I don't have time to assign it, it's called Bailey versus Alabama, Bailey, Bailey versus Alabama. It's in your book, you can find it. And it actually involved a statute that made it a crime to violate a labor contract. So let's say you signed a contract to work, however many hours, right? You have to work a certain amount of time. If you didn't do that, it was not only a breach of the contract, it was a crime itself. And they could throw you in jail and incarcerate you for breaching that contract. And then once you're incarcerated, they can make you enslaved. So I think you raised a very fair point, Victoria. I don't think that was the intent in 1865 when they wrote this, but it quickly became exploited in that fashion. I think they were just worried that if this was in the Constitution, the prisoners would all freak out and say, okay, I'm a slave. A good point. Thank you, Tori. All right. I want to walk through the three cases, but I don't have nearly enough time to do it, but I'll do my best. I encourage you to watch the videos for these ones. These are, I think, some of the best videos in the package. We did the one of the Reconstruction Amendments was our longest video. It's like 25 minutes, almost like a sitcom, right? But it's one I think we're very proud of. At least I am. Randy, I think, as well. I think I speak for both of them. All right. So there were three cases decided in the wake of the 14th Amendment. Again, the 14th Amendment was decided in 1868. Right? 14th Amendment was decided in 1868. And then there were a series of test cases that came later. About 5 years later. The first two were in 1873. The first was called Slaughterhouse Cases. And the second was Bradwell v. Illinois. The next case was a little bit different. Came in 1875, was U.S. v. Cruikshank. All right? These are really important cases. Really important cases. Because they were the Supreme Court's first effort to interpret the 13th and the 14th Amendments. This was like the first shot. And again, keep in mind we're less than a decade from the Civil War. All right. The Slaughterhouse case is kind of a weird case. You would think after the Civil War, you would have a case about racial discrimination. Like that's your first test case. But it's not about racial discrimination at all. It's about a bunch of butchers. Like, why was this the first test case? There's a long history. I don't have time into it. But this is a very strange test case to me. So what happened? The Louisiana government said, we are going to create a monopoly. We're going to give one company a monopoly on slaughtering animals. So if you have livestock in New Orleans, you couldn't slaughter it in your own facility. You had to bring the livestock to a central slaughterhouse. So it was basically a butcher shop, right? It was this huge butcher shop where you'd have, it's kind of gross, right? The cows enter on one side of the building and they exit as beef on the other side, right? It's just, I'm sorry, it's gross, but it's true, right? They would enter one side, they wouldn't leave the other side, right? They would be slaughtered in this facility. It was this very long, these long buildings. The butchers argued that this monopoly was unconstitutional. Now, there was nothing in the original federal constitution that limited this, right? The original constitution said nothing at all about. It said nothing at all about limitations on butcher shops. But the butchers argue that the 14th Amendment changed the calculus, changed the situation. Specifically, they look to the so-called privileges or immunities clause. And the butchers argue that this phrase privileges or immunities refer to certain rights. Now, what are these privileges or immunities? It's not entirely clear. But one of the common understandings of this phrase was that a privilege or immunity referred to a right to pursue an occupation, what you might call the right to earn an honest living. And they argue that this Louisiana law was arbitrary, that it deprived them of their property because they can no longer use their own slaughterhouses. Okay? So they brought this lawsuit. And they argued that the Louisiana law was unconstitutional. They lost. They lost 5-4. Now, they probably deserve to lose because I think their claim was weak, right? We can be candid here. This sucked for their businesses, but there was actually a decent health reason for this law. Louisiana was having a serious health crisis. People were basically butchering their animals everywhere and then dumping the blood into the river. It was kind of gross, right? So there was, there's bug infection. There's plague. There's a lot of good reasons to clean up the act, so to speak. So I used to think this law was arbitrary, but I've done some more homework, and now I see this was probably a reasonable law. I mean, I wouldn't have done it this way, but I think that it's probably within the state's power to do this. Okay. But the court goes beyond that. And the court doesn't just say, well, you have this right, but this law I think is a reasonable regulation. The court goes further and they say, this phrase privileges or immunities is very narrow. It doesn't refer to this body of unenumerated rights, like right to earn a contract. It's limited to a special set of federal rights, right? These are only the rights of national citizenship, right? What rights are really important to being a citizen of the United States? Those are your privileges or immunities. What are some of the examples? The right to visit the government, protection of the high seas, access to the treasuries, accessing courts of justice. This was, a list of federal rights, but almost not everyone, but almost every Commonwealth scholar today thinks this was wrong. That the court basically strangled the privileges or immunities clause in its crib, right? They suffocated it of any meaning. And they made it almost meaningless. It had no meaning. At this point, the privileges or immunities clause is a dead letter. To this day, here we are sitting in the year 2020, the privileges or immunities clause is dead. It has no teeth. It doesn't mean anything, right? It refers to a useless series of rights that don't have any relevance. So you have this bloody civil war, and you have this significant constitutional amendment, the 14th Amendment, which was designed to give Congress all these powers to protect rights. And then what happens 5 years later? Supreme Court says, no, just kidding. Doesn't really mean anything. Basically, the Supreme Court was maintaining the status quo before the Civil War. Fine. No slavery, that's it. But they will not take a step beyond that. This was very, very significant. The Privileges or Immunities Clause was the crown jewel of the 14th Amendment. This was the centerpiece of the 14th Amendment. It was first. It was listed right at the beginning, right after citizenship, right? You get citizenship, and then you give rights, right? That was the sequence. First, you're a citizen. Second, you get rights. That was the chronology. And the court said, fine, you're a citizen, but you get no rights. This decision, I don't want to oversell it, but this decision paved the way for Jim Crow. Once you say the states are not bound to protect certain fundamental rights of the people, the states can then violate those rights. There are other decisions will come later, but this was like the first case that paved the way. Most people have never heard of Slaughterhouse. It's not a very well-known case, but it was very significant, right? I mean, this was 1873. Plessy was 1896. Might be off by a year, but I think it was 1896. So there were 2 decades between Slaughterhouse and Plessy. But you don't get to Plessy without Slaughterhouse, right? Plessy was a byproduct of other decisions like Slaughterhouse that read the 14th Amendment narrowly, right? That's the chronology, right? 68 was when the 14th Amendment was passed. 73 was when you have Slaughterhouse. And then you get to Plessy 96, right? In that 20-odd year window, 25-year window, the entirety of the Reconstruction Amendments was just killed. From 1868 to 1896, right? Less than 33 decades. In fact, Randy and I were working on our book title, and I think the working title is probably going to be Slavery in the Constitution from 1776 to 1896. So basically from the Declaration to Plessy. That's, I think, it's going to be the beginning and end. Because once you get to Plessy, it's basically over, right? It's basically a done deal. The Supreme Court's like, we're not getting involved. It's not a problem. And that wouldn't change for the 1940s and 50s, which we'll cover later. Shawnee asks in the chat, could you please clarify the difference between the privileges? Okay, I'll be happy to. Let me turn the screen sharing on for a moment. I usually don't make this point because it's complicated, but Shawnee has. I'm happy to answer her question. All right. Article 4 of the Constitution contains a number of provisions. One of them is called the Privileges and Immunities Clause. The Privileges and Immunities Clause. It's in Article 4, Section 2. And it says, the citizens of each state shall be entitled to all privileges and immunities of citizens in the several states. This provision is a discrimination provision. So, for example, if Texas gives certain rights to its citizens, and then you travel here from Louisiana, Texas must give you the same rights it gives to its own citizens. In other words, if there's a traveler from Louisiana, Texas cannot deny these rights to a Louisiana citizen who's traveling, right? This doesn't say what those rights are. It says whatever rights you give to your people, you have to give to foreigners, right? This was an important provision because if slaves were citizens, surprise, surprise, they would get these rights. This is one of the reasons why Tawny was so adamant that slaves could not be citizens. Because if slaves were citizens, they would get privileges and immunities. But Tawny says you cannot be citizens, therefore you don't get these rights. So the Article 4 of the Privileges and Immunities Clause simply said states cannot discriminate against out-of-staters. But the 14th Amendment is not privileges or immunities. It's different. I'm sorry, the 14th Amendment is privileges or immunities. You can remember it this way. In Article 4, it's privileges and immunities because and comes before or, right? You first have and, then you have or. An alphabet. Privileges and immunities in Article 4. Privileges or immunities in the 14th Amendment. The 14th Amendment does something different. It's not a discrimination provision. It says that no state can violate the privileges or immunities of citizens of the United States. Right? This wasn't about treating foreigners equally. It was about treating your own people with certain rights. Now, what were those rights? Privileges or immunities. What are privileges or immunities? The Supreme Court says nothing really important. They kind of laughed at it. So the upshot, right? The upshot of Slaughterhouse is it read the 14th Amendment privileges or immunities clause basically into oblivion. It had no teeth after this. Okay? Shawnee asks, the reason why the butchers couldn't rely on Article 4 is because they were citizens of the state and not foreigners. Close. The Article 4 clause only discusses discriminating against foreign citizens. It doesn't say what those rights are. Louisiana didn't give anyone this right to freedom of contract. Therefore, they couldn't rely on that provision. They had to go to the federal constitution in the 14th Amendment. All right. Questions on Slaughterhouse? All right. The day after Slaughterhouse was decided, we get another case, which, also not an easy one to read. Bradwell v. Illinois. This case was not about a butcher, but about an attorney. A woman, well, she wanted to be an attorney, and was Myra Bradwell. Her husband was an attorney, and she was studying as his apprentice. And Bradwell argued that, this right to pursue an honest living, this right to earn a living, was a privilege or immunity of citizenship. And the 14th Amendment says nothing at all about, Section 1 at least, Section 1 says nothing about gender. It's just persons. Majority says, sorry, no luck, right? The butchers don't win, you don't win either, sorry. I guess that makes sense in terms of the majority opinion. If the privileges or immunities clause protects a very narrow set of federal rights, then that doesn't matter whether it's working as a butcher or working as an attorney. It's up to the state. But you may recall Slaughterhouse was not 9-0, it was 5-4. And then what happens to the dissenters? The dissenters said, well, the butchers have this right, but women don't. How did they figure this out? So we get Justice Bradley, who writes probably one of the most unpopular decisions in this semester. I think it's up there. It's not quite anti-canon because it's dissent. You can't really have an anti-canon dissent, but if you could, it would be up there, I think. And he basically says, well, the butchers have a right, but women don't because women are inferior, right? They are destined for the home, for the kitchen, to raise their noble pursuit of raising children. That's all they're there for. And you can read it. I mean, it's stunning, but he has to sort of twist himself in these pretzels to rule for the bakers, but not bakers, to rule for the butchers. The butchers, the bakers, no. To rule against the butcher, to rule for the butchers, but against the female attorney. The majority follows. The only dissenter in both cases was Chief Justice Chase, who Randy is a huge fan of. So that's why he figures so prominently in our book. He loves Chase. I like him too, but not like Randy does. Randy is takes pictures at his graves. It's a thing for him. But Chief Justice Chase was dissenting in both cases. He was also quite ill at this point. He died a couple weeks after these cases, so he didn't really have the energy to write a dissent. And I think that matters, right? I think, you get a dissent in Dred Scott from Curtis. You get a dissent in Slaughterhouse from Justice Field, and you can see both sides. There is no dissent in Bradwell, and I would have liked to have seen a dissent. I think that's something that would be useful to see, defending the right of the attorney to get a female attorney to get her license. But alas, we don't have that. Oh boy, running so quick. Okay, I hate it. I hate these short classes. Questions on Bradwell or Slaughterhouse? No? None? Okay. All right. The third case for today is a gruesome case. It's probably one of the most gruesome cases we have this semester. It's got to be up there. This is not often considered an anti-canon case, but I think it probably should be. Yeah, Macy, go ahead.
I changed my mind. I had a question about Bradwell before we move on, if that's okay.
You can ask it, please.
Okay. So, I mean, the opinion is about, There's nothing mentioning gender for your right to make a living. That's why she can't be a lawyer. It's up to the state. But the Constitution doesn't say anything about women's destiny to be homemakers. So, like, they just pulled that out of their butts just because they felt like it? Like, there's no constitutional basis there.
Well, I'm reminded of Dred Scott, right? Where did Tawny get his history from? From his butt? No, I'm sorry, that was me. I shouldn't have said that, right? That was... I know you're with it. I'm sorry. That was a little crass. I apologize to the class. But I think Laney made a point similar earlier. He was making this crap up, right? I mean, just this was not in the Constitution. It wasn't in any document. He was just merely describing the state of things as he saw them. Now, let's be candid here. At the time in the 1860s, women didn't have any rights. Let's just be candid here, right? At the time, the institution of coverture. Did you say that in property? Coverture? Right? Under coverture, married women could not own property. And this was actually an important part of the case. If you're an attorney, you have to make contracts. But under Illinois law, a married woman cannot make a contract. So she was actually illegal. She was legally barred from doing the things a lawyer has to do, which is something that the state court relied on. So there was some accuracy to what he's saying, but this entire philosophical rant was just completely unnecessary. It reminds me of Dred Scott, the way he talked about the unfortunate race. It just has the same sort of resonance that he needs to make his point of the inequality to make his legal point stand. Does that make sense, Macy?
Yes, it does.
Yeah, but no, I get it. Yeah, every year students are like, what the hell is this? You're making me read Dred Scott one week and making this read the next class, back-to-back classes. This part of the semester is a little bit rougher. I'm probably going to go over by a minute or two. Any questions on Bradwell or Slaughterhouse? Okay. Let me move on to Cruikshank, which I think is a very significant case. It doesn't get nearly enough attention as it deserves. Very important case. Slaughterhouse and Bradwell asked whether the Privileges or Immunities Clause protects an unenumerated right. Okay, what do I mean unenumerated right? A right that's not written down, right? It just says privileges or immunities. It doesn't say a right to a contract. It doesn't say a right to earn a living. It just says P or I. Cruikshank had, I think, a far stronger case that the provisions of the Bill of Rights, the rights to bear arms, the right to peacefully assemble, were privileges or immunities. On this one, Cruikshank is dead wrong, right? If you look at the debates for the ratification of the 14th Amendment, it was pretty obvious they thought that the first 8 amendments were covered. Not everyone agrees. There's some people disagree. I don't want to say it's unanimous, but it's a pretty strong argument that the Second Amendment was a privilege or immunity. Cruikshank arose with an awful lynching. Read the facts in the case. Watch the video. But what happened here was a white lynch mob set a courthouse on fire and burned alive an entire contingency of freedmen. They just burned them alive. And those who were not burned alive, they were shot, killed, and dragged down to the river and tossed in the river. Gruesome, called the Colfax Massacre. I actually found this out recently. If you go to Colfax, Louisiana, there's actually a statue that honors, no, not the people who were killed, but the people who were in the lynch mob. I'm not joking. I found this out a few weeks ago. If you actually go down there, there's actually a statue honoring the brave people in the lynch mob. I'm generally not one of the people saying take down statues, but that's a statue that's probably removed soon. The federal government brought a prosecution against the lynchers. The one guy's name was Cruikshank. And Cruikshank argued to dismiss the prosecution. And the government said, no, we can prosecute because Cruikshank violated the civil rights of the freedmen. Now, you might say, Josh, why didn't they just charge him with murder? There was not a federal murder statute in the 1860s, right? Murder is not a crime in the federal government, right? Unless you're shooting a bullet across state lines, murder is a state crime. There was no federal murder statute at the time for local murder. Instead, they argued that Cruikshank was violating the civil rights, was violating the privileges or immunities of the freedmen. Well, wait a minute. In order to violate the privileges or immunities, we have to ask, what is a PRI? Cruikshank said the right to bear arms is not a PRI. Therefore, I didn't violate their rights. The right to peacefully assemble is not a PRI. And the Supreme Court agreed with Cruikshank, and they reversed his conviction. And the court said that the first 8 amendments are not privileges or immunities. Barron v. Baltimore, remember that case? Chief Justice Marshall? Barron was still good law. Even though we now have the 14th Amendment, Barron was still good law. And therefore, the states were not bound by the first 8 amendments. And Cruikshank walked. And he was not convicted. And this would remain the law for about 40 or 50 years. Eventually, the Supreme Court began to hold that the provisions of the Bill of Rights are applicable to the states. The states are bound by the Bill of Rights, but that wouldn't happen until the 1940s. So let's just recap, and I'll start the minute poll now. If you need to go, please, I want to keep you. We have these amendments, 13th and 14th Amendments, which were designed to nullify Dred Scott. But within the span of 5 years, barely 5 years, you have Slaughterhouse, Bradwell, and Cruikshank. Slaughterhouse and Bradwell hold that the 14th Amendment does not protect these sort of unenumerated rights. And then Cruikshank holds the 14th Amendment also doesn't protect enumerated rights, the Bill of Rights. So what are we left with? The Privileges or Immunities Clause is a dead law. In our class for next week, we'll talk about the Equal Protection Clause in Section 5. The Supreme Court, surprise, surprise, would gut those provisions as well, which allowed separate but equal. So throughout this entirety of the 4 decades after the 14th Amendment, the Supreme Court basically nullified these provisions. They didn't touch the Due Process Clause. We'll get to that one later. That was actually very curious. But over time, PRI and equal protection wiped off the books. Okay? Questions before I head out?
I have a question.
Yep, go ahead.
When you said it wasn't until the 1940s that the states became bound by the Bill of Rights?
It wasn't all at once either. It was incremental. It happened a little bit at a time.
Okay, so I'm sorry if I just missed, history too in college, but why was it not until the 1940s?
It's historical quirk. The Supreme Court stuck by Cruikshank forever, and eventually they realized that it was a bad idea, and they started to move away from Cruikshank. That's the short answer.
Okay, thank you.
My pleasure. Anything else?
Would you please repeat the 3 holdings you just said? I was furiously trying to organize my notes and couldn't write at the same time.
Okay. Slaughterhouse reduced the Privileged Immunities Clause and said it doesn't protect unenumerated rights. Bradwell is the same. And then Cruikshank held that the Privileges or Immunities Clause doesn't apply to the Bill of Rights, not the enumerated rights as well. Okay? All right. I think I've kept you all long enough. I'll be back in about 15 minutes or 20 minutes, okay? All right. Thank you so much.